Hi folks, and welcome back to Contract Law. This is video 4 in the video series for the vitiating factors of duress, undue influence and unconscionable conduct, and I call them the V3. In video 1 we had an overview of the topic. In video 2 we looked at duress. In video 3 we looked at undue influence, and in video 4 we will look at unconscionable conduct. So, looking first at unconscionable conduct, generally speaking, the first thing we need to say about unconscionable conduct is that the focus of the court in when arguments of unconscionable conduct are made will be upon the stronger party's conduct, so quite different to both duress and undue influence. The focus is not on the will or the consent of the party with the special disability or special disadvantage, as they call it in the case law. We look instead to the advantage taken by the stronger party. So, as I said, you're looking at the stronger party's conduct and placing it under a smell test.
Do you smell it? That smell.
Okay. If there is something sharp, as in sharp practice, if there is something untoward, then it may well be a case of unconscionable conduct. You need to prove that one party is in a position of special disadvantage or special disability, that the other party knows or ought to know. So there's the link. There's the link, ought to know of the special disadvantage, and then notwithstanding that, they go ahead and take advantage of the unfair advantage and seek to retain the benefit. So the big case here is a case that's near and dear to my heart, Commercial Bank of Australia and Mario. This case came down in 1977. And it was in relation to conduct that went down in Adelaide, which is my old hometown. We had the protagonist being Mr. Vincenzo Mario, rather flashy business person for those days. There was evidence in the case given that he had held a Christmas party for more than 2,000 people, 2,000 of his closest friends. However, despite his high public profile and media presence, his company was unfortunately going broke. Wasn't terribly good at managing money. Nevertheless, the commercial bank at the Glynde branch liked him very much for a few reasons. Obviously, he was an important customer and probably the most important customer of that particular branch. He brought in a significant amount of business for the bank from his large network of affiliates. And interestingly, he was engaged, his building company was engaged in a joint venture with a subsidiary of the bank in which they were doing some property developments. So they had a pretty special relationship, Mr. Vincenzo Mario and the commercial bank at Glynde. The bank knew that Mr. Mario was not terribly good at managing his money, and they knew of his parlous circumstances so far as his company was concerned. And rather extraordinarily, the bank manager, a Mr. Virgo, used to meet with Vince on a daily basis to go through all of the checks that he had presented to various parties and work out which of the checks they would honour and which of the checks would be dishonoured. Now, this conduct by the bank really allowed Mr. Mario to continue to operate his company with a facade of solvency when he really was teetering on, if not already insolvent. Finally, the overdraft that he was originally given was around about, I'm going to say $80,000. It escalated to about $189,000. Then it shot up to about $270,000. The bank got worried, obviously, and said, "Look, sorry, we're going to put a freeze on your account." Vince wasn't too happy about this at all.
Shut up, will you?
They said to him, what we'll do is we'll continue our banking relationship with you if you'll agree to open a second bank account and keep that bank account in credit and start chipping away at the rather large overdraft you have on your other bank account. Vincenzo obviously agreed to that. However, within days, that second bank account was overdrawn, so a bit of a spender, incapable of restraining himself so far as money was concerned. Then what happens? Vincenzo doesn't like the constraints that the bank has placed upon him, and so he decides to cook up a little scheme. He goes up to the Bank of New South Wales up the road and opens an account, and then he goes back to the commercial bank and he says that the Bank of New South Wales, he not only opened an account there, but that they had given him an overdraft facility on the security of a little office block that his parents had owned. That was a lie. Vincenzo says, look, I'm going to take my business away from the commercial bank unless you give me the same kind of deal here. I can give you some security in terms of my parents' little office block if you'll give this overdraft to me so I can keep spending money.
Money, money, money.
The bank, incredibly, said yes if Vincenzo this time would really set about reducing the large debt that he now owed the Commercial Bank of Australia. He said, of course I will, and it's already a done deal. My parents have agreed to provide the security for me.
No.
That was a lie. He then had to approach his parents over lunch and ask them if they would provide the security. They agreed. Part of that conversation involved Vincenzo telling them that it was only for about $50,000 and only for a period of 6 months. So there was relatively little risk so far as the parents were concerned. Again, another lie. So what happens then? Vincenzo goes to Mr. Virgo. It reassures him that everything is all good and agrees for Mr. Virgo to approach his parents and take the document, the large mortgage document, to his mum and dad's home for signature. The document, in fact, was not limited to 6 months. It was unlimited as to time, and it was not limited to $50,000. It was an all-monies mortgage. So signing on the dotted line for Mr. and Mrs. Mario would have been pretty much financial suicide. It was even found by the court that at this point the security they were offering wouldn't have even covered Vincenzo's debt. So it really would have been financial suicide. What happened then? The mortgage that was presented by Mr. Virgo of the Glynde branch of the bank to Mr. and Mrs. Mario was done in fairly extraordinary circumstances. As I said, it was in Mr. and Mrs. Mario's home, which is odd for such a serious financial transaction. Mr. and Mrs. Mario had limited grasp of written English. Now that was certainly important because the document that he actually plopped on the table for their perusal was extraordinarily long. The court found it was 18 separate covenants of meticulous legal drafting that would discourage careful perusal by even a seasoned English speaker. As I said, the document was unlimited as to amount, unlimited as to time. It was an all-monies mortgage, so the bank was really going to improve their security situation very significantly by this deal. It had little confidence in Vincenzo's ability to restrain his spending. So Mr. Mario was relaxing after lunch, reading a newspaper, and Mrs. Mario was washing dishes when Mr. Virgo came in, plopped this document on the table. Mr. Virgo knew that they didn't bother to read any of the document. Wouldn't have done them much good anyway. As I said, they had limited grasp of English. They just proceeded to sign it. Now, before they did, there was one really significant circumstance, and that was Mr. Mario said, "This is for 6 months only," and Mr. Virgo, instead of giving him any proper advice on the document, says, "No, it's not the case. It's not for 6 months only." And he just said, "The document won't be registered for now," and proceeded to let Mr. and Mrs. Mario sign. They weren't given a copy of the document, and you guessed it, Mr. and Mrs. Mario thought everything was done and dusted. They thought they had an honest, trustworthy son. They thought that his business was prosperous. They didn't hear anything from March 77 when they signed up until December 1978. And then the world came crashing down for them, unfortunately. The bank called in the security because Vincenzo Mario's business obviously went south, so to speak. And they wanted to take the little office building that Mr. and Mrs. Mario had put on the line. Chief Justice Gibbs's judgment is very interesting, and he resists the notion of importing this doctrine of unconscionable conduct. He says really there's no need for it because this decision can rest upon what he saw as a misrepresentation by the bank, and he goes through the kinds of things that a bank, in seeking security from a guarantor, would be required to disclose to the security providers. You don't have to tell them how bad the person that is being secured, how bad their credit is. All of those things were fairly obvious to a guarantor because otherwise the bank wouldn't be seeking a guarantee. But they said things like the special relationship that the bank had with Vincenzo, the fact that it had been dishonouring the checks, these kinds of things took the relationship that the bank had with Vincenzo out of the usual transactional relationship and made it into something a little bit more unusual, and that is what should have been disclosed to Mr. and Mrs. Mario. It wasn't, and therefore Gibbs would have held that the contract was voidable for misrepresentation. So here you see, as I said, the coalescence of these vitiating factors. You may be able to argue more than one on the same fact scenario. Justice Dawson took a little harsher line and said, sorry, no, I'd allow the appeal. No misrepresentation, no unconscionable conduct, and he would have left it at that. However, thankfully for us, the plurality, that was Mason, Wilson and Justice Dean, all agreed that the contract, the security contract, should be voidable for unconscionable conduct. And Justice Dean's decision is particularly a strong one, and I like it a lot. From that decision, he says, unconscionable dealing looks to the conduct of the stronger party in attempting to enforce or retain the benefit of a dealing with a person under a special disability in circumstances where it's not consistent with equity or good conscience that he should do so. The adverse circumstances which may constitute a special disability for the purposes of principles relating to relief may take a wide variety of forms, not susceptible to comprehensively cataloguing. So he's saying this is an equitable doctrine. We're not going to prescribe any particular set of circumstances. You've got to be able to go with the flow a bit in terms of what circumstances you find. However, he gives a quote from an earlier case, which is also delightful. Blomley and Ryan, if you get a chance, definitely read that one. And in that case, Fulliger said that examples of a special disability or special disadvantage would be poverty or need of any kind, sickness, age, sex, infirmity of body or mind. Not sure about sex. That just occurred to me. Drunkenness, illiteracy or lack of education, lack of assistance where they are plainly necessary. So, as Fulliger said, the whole sum of those kinds of circumstances is that they place one of the parties at a serious disadvantage, or, as the other judges said, special disability vis-a-vis the other party. And what was the special disability or special disadvantage in this case? Well, the court had a look, Justice Dean in particular, had a look at the relative positions of the parties. The bank here was a major national institution. It knew about Vincenzo's company's dealings, insolvency. It knew about the overdrawn accounts, the tendency to exceed borrowing limits. And the whole point of the transaction was to improve their position and secure Vincenzo's debt. It knew, obviously, what the contents of the document were. On the other hand, Mr. and Mrs. Mario, not such an advantageous position, were they? They were elderly. There was little grasp of written English. They had relied on Vincenzo to manage their business. They believed that Vincenzo was prosperous, successful. This was all done in a situation of great informality in their own home, in their own kitchen. He was reading the papers, she was washing the dishes. No one was expecting such a serious event to come and go without the attendant seriousness in the surrounding circumstances that the deal was done in. There was a complicated, lengthy document presented to them. They'd never been given any advice on it. Vincenzo had lied to them about it. Mr. Virgo didn't explain it, and the sum total of all of that, they lacked assistance and advice where assistance and advice were plainly necessary. This all added up to a special disability, enough for equity's jurisdiction to be enlivened and equity to intervene, step in, render the contract voidable and relieve from the unconscionable conduct. The only real question then, and it was a rather nice point of legal argument, did the bank know about Mr. and Mrs. Mario's special disability or special disadvantage? The court held that yes, the bank had acted via Mr. Virgo. Virgo's acts were those of the bank. His knowledge was the bank's knowledge. The bank tried to weasel out of it and said that they'd relied on a statement by Vincenzo to them that he told Mr. Virgo he explained the transaction fully to his parents. The court said that evidence that Vincenzo had ever said such words was unimpressively sparse. There was certainly no proper basis for assuming that Mr. and Mrs. Mario got adequate advice. I mean, at the point where Vincenzo had said he'd explained the transaction fully to them, Mr. Virgo knew that Vincenzo hadn't even read the document at that point. So, given that there was 18 covenants of meticulous drafting, there was no way there could have been a full explanation given. He knew that the Marios hadn't read the thing. The real red flag for the bank was that Mr. Mario had commented that this was for only 6 months. That should have very clearly signalled to Mr. Virgo that the Amarios were seriously misinformed as to a basic term of the proposed agreement. At that point, the bank was then put inquiry. Mr. Virgo should have made sure that they understood the terms of what they were about to agree to. So effectively, the bank was willfully ignorant via Mr. Virgo of the Amadio's special disability, and that was not distinguishable from actual knowledge of their special disability. For Mr. Virgo to go ahead and procure execution of the document in those circumstances was unconscionable. Therefore, as I said, the document was set aside. Rescission is the usual remedy here for unconscionable conduct, much like duress and undue influence. the usual bars apply. So that is CBA and Mario. Excellent case for illustrating the nature of the unconscionable conduct vitiating factor and how it differs from both duress and undue influence in the focus that the court takes. One last case that I wanted to briefly run through with you because it actually illustrates quite nicely how the vitiating factor of unconscionable conduct can apply in a very, very wide variety of circumstances. And here you had a special disability or special disadvantage being infatuation in a romantic relationship. And here the weaker party of the two was actually a solicitor. The stronger party was his sometime girlfriend, Duress, Miss Duress. It was one of those she's just not really that into you kind of scenarios. They got together, Mr. Louth and Miss Duress. She put up with him principally because he gave her stuff, material benefits. Duress said that she needed a house. She was living with some relatives. She told Mr. Louth that she was being evicted, and she said, look, I can't face the whole prospect of myself and the kids being out in the street. If that happened, I'd kill myself. Those words for Mr. Louth were like a dagger to the heart. He couldn't face the world without Ms. Duress in it. And the fact that she had falsely manufactured this atmosphere of crisis played very heavily on Mr. Louth's ability to decide rationally in his own best interest, and it put him in a position of special disability or special disadvantage. He felt extraordinarily vulnerable. He gave her almost $60,000 to go buy the house for her and her kids. And subsequently, you guessed it, Mr. Louth and Ms. Duress had a falling out. He very nicely went to her and approached her and said, can you please pay me back the money? She, perhaps unsurprisingly, refused to pay back the money, so he sued to recover it. Surprisingly, possibly, the case was fought all the way up to the High Court, and in all of the judgments you can see the judges finding Ms. Duress's conduct quite reprehensible and painting her as quite the wicked woman. The judges found that Louth's emotional dependence on her, his infatuation, vulnerability in thinking of her evicted and potential suicide was that special disability that was sufficient for then equity's jurisdiction to be enlivened and equity to race in and save the day. Duress had manipulated the circumstances to her advantage to get the money. She used his love or infatuation and deceit, the court found, to get what she wanted. The transaction, clearly from Louth's point of view, was most improvident, and it was held that where conduct is unconscionable, equity will protect not just from foolishness, foolish transactions, like this one was for Mr. Louth, but also from victimisation, which is effectively what the court, as I said, had found Duress had engaged in, painted her as the very wicked woman. So that's Louth and Duress, yet another rather interesting case of unconscionable conduct. The very lucky last thing that we need to mention here is that there is a statutory basis for unconscionable conduct now. It's in the ACL, sections 20 and 21. And in section 20, we see that the legislation now prohibits in trade or commerce. There's that phrase again. So it doesn't catch private conduct, it catches conduct in trade or commerce. Given that it's within the consumer law, this is directed at consumers. A person must not in trade or commerce engage in conduct that's unconscionable within the meaning of the unwritten law from time to time. What does that mean? It simply means within the meaning of case law. Unwritten law means case law. Written law means statutory. law. So it was intended to sweep into the ACL the ability to catch conduct like the CBA and Mario case. And in fact, the CBA and Mario case is mentioned in the explanatory memorandum that accompanies the introduction of this provision. What does this do? It allows a plaintiff to plug into all of those groovy remedies that are in the ACL, like 236 damages and 237/243, ability to tailor those remedies exactly for the situation that is in front of the court. All of those lovely remedies that examples are given in 243. Section 21 deals with conduct, unconscionable conduct in relation to goods and services. Section 22 gives a nice long list, non-exhaustive list of the indicia that a court can look at. Go and explore that. I would strongly encourage you to do so. This is really valuable stuff because those extra remedies you can get in the ACL are well worth investigating. There's some other legislation that you should probably look at. I'll leave you to look at the text for those. And that is unconscionable conduct. And that is the V3, the vitiating factors of duress, undue influence, and unconscionable conduct. And as I always say, if there are any queries and questions that you still have after this video series, please don't hesitate to jump into Teams, send me an email, Facebook me. And I'm sure that we can get it sorted out for you. Other than that, I look forward to catching up with you in a tutorial sometime soon. And until then, it's bye for now, guys.